Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
You know, usually when we talk about a medical diagnosis, there's this underlying expectation of precision. It feels almost like engineering.
Well, right. It's very binary.
Exactly. Like if you break your arm, the x-ray shows that jagged white line on the black film, and the doctor just points a pen at it and says, there it is. That is the fracture.
Sure. It's either broken or it's not.
Right. And there's a profound comfort in that.
Yeah.
We as humans desperately like things to be visible, to be neatly categorized, and be undeniably proven. Mm-hmm. But then you step into the world of employment law.
Oh, yeah. That x-ray machine doesn't work there.
It's completely broken, especially in the highly charged realm of workplace discrimination and retaliation. Suddenly you realize you're no longer looking at high contrast images of bone. You're looking at an incredibly murky diagnostic landscape.
It is the absolute definition of muddy waters. Because, in an employment dispute, you aren't examining a static object. You're trying to diagnose human interactions. And invisible power dynamics, layered corporate bureaucracy, and in many cases, decades of interpersonal history.
Yeah, and all of that messy reality is being filtered through the vastly different, often intentionally self-serving memories of the people involved.
Exactly. It's an environment where an offhand comment to one person is, frankly, a career-ending injury to another.
Which brings us perfectly to our focus for today. Welcome to another episode of the Employee Survival Guide podcast. Today, we are examining a massive, incredibly dense stack of federal court documents straight out of the Southern District of New York.
It's a heavy one today.
It really is. The case we are unpacking is Wanda Wilson v. JPMorgan Chase Bank, N.A., case number 20-CV4558. We are going to conduct basically an autopsy on a high-stakes corporate employment discrimination lawsuit.
And to do this properly, to really see the mechanics of how these battles are actually fought, we have three very distinct lenses provided by our source material.
Right, three separate documents. The first document is the plaintiff's second amended complaint,
which is deeply personal.
Extremely personal. It's a highly detailed and emotionally charged narrative laid out by Wanda Wilson herself, spanning over 2 decades of her life at the bank. Then, the second document is the defendant's answer.
Right, the bank's response.
Yeah, this is JPMorgan Chase's official legal response, drafted by a major international law firm, and it serves as an absolute masterclass in sterile, strategic, defensive posturing.
It's like a fortress made of paper.
Exactly. And finally, we have the federal judge's opinion and order. This is the referee stepping onto the field, applying centuries of jurisprudence to decide which of these explosive claims actually survive, to see the inside of a courtroom.
And our mission for you, the listener, is to pull back the curtain on this entire process. We want to show you exactly how extreme workplace allegations are leveled in a federal complaint, how a massive multi-trillion-dollar corporation legally insulates itself against those allegations, and, how federal judges act as the ultimate filter.
Right, applying incredibly strict legal standards to deeply emotional human conflicts. We are looking at the foundational architecture of the lawsuit itself.
But before we turn the first page, we really need to set a firm boundary.
Yes, very important. We need to be very clear with you. The documents we are analyzing today contain politically charged and highly racially sensitive allegations.
Yes, they do.
We are going to be discussing claims of overt racism, severe emotional distress, and institutional hostility. So we want to state unequivocally that we are not taking sides here.
We're not endorsing any viewpoints.
Right. And we are not declaring what is absolute objective truth or falsehood. Our job today is strictly and impartially to analyze the claims, the defenses, and the judicial rulings exactly as they appear in the source documents.
We're simply conveying the ideas and the legal arguments contained in the original material so you can understand the machinery of the law.
Setting that baseline is crucial, right? Because the machinery of the law relies entirely on the facts pleaded.
Exactly. So to understand how this specific machine operates, we have to start at the very beginning of the timeline established by the plaintiff. We need to look at the picture Wanda Wilson paints of her early career.
Let's wind the clock way back to 1997. Wanda Wilson, an African-American woman, begins her career at JPMorgan Chase. She's hired as an executive administrative assistant.
And according to the narrative built in her complaint, for the next 20 years, she achieved meets or exceeds expectations on her performance reviews.
20 years.
Yeah.
And she was never formally reprimanded, never disciplined. The complaint goes out of its way to establish her as a dedicated, exceptionally hardworking employee who really understood the grueling demands of high finance.
She is building a very specific profile here for the court, which is legally strategic.
Right. The 20-year baseline is the foundational pillar of her entire strategy.
Yeah, because in employment law, the plaintiff must first establish what we call a prima facie case.
Which means on its face, right?
Exactly. And one of the core requirements is proving you were actually qualified for the job and performing it satisfactorily.
So by establishing 2 decades of stellar reviews, she's preemptively blocking a very common corporate defense.
Right. She is establishing herself not as, a disgruntled, underperforming new hire who is just making excuses. She's a loyal, proven, long-term asset to the institution.
But the narrative she builds is that this long-term asset was subjected to a fundamentally hostile environment almost from the jump.
Yeah.
And the inciting incident of her specific narrative, at least in terms of the timeline laid out in the complaint, is unimaginably tragic. In 2003, Wilson's sister was brutally murdered by Wilson's ex-husband.
It's a horrific personal trauma.
Beyond horrific.
Yeah.
So she obviously had to take time off work. And initially, the bank seemed supportive. The complaint actually notes they paid for a hotel while her home was an active crime scene.
But the friction begins the moment she returns to the office.
Right. The return to work is where the complaint alleges the first major structural crack in the foundation of her employment occurs.
Right.
She alleges that upon returning, the head of her department at the time, a non-African-American man named Doug Traver, walked up to her desk.
And this is where it gets very dark.
Very. According to the documents, he had a smirk on his face and said, and I'm quoting directly from the complaint here, "Welcome back. So I heard your husband killed your sister. So what exactly happened?"
Wow. I mean, a statement like that, if true, sets a breathtakingly callous psychological baseline for the rest of the narrative.
I can't even imagine.
The complaint notes she reported this immediately to another manager who apologized and let her go home for the day. But legally and narratively, this moment introduces the overarching theme of the lawsuit.
Which is isolation and a profound lack of basic human empathy.
Right. Or perhaps just a complete lack of basic professional decorum from superior officers at the bank.
I want to pause here and ask the question that I think a lot of people listening are probably shouting at their speakers right now.
Why didn't she leave?
Exactly. If someone experiences such a staggeringly callous comment about the murder of a family member in 2003, why stay? She alleges she saw systemic disparities in how African-American employees were treated regarding promotions and pay. And she experienced this horrific interaction, yet she stayed for another 15 years.
It seems counterintuitive.
Doesn't that severely complicate a legal narrative later on? I just imagine a defense attorney standing in front of a jury and simply asking, if it was a daily nightmare, why didn't you just leave?
It is the most common intuitive question people ask. But in the specific realm of employment law, retaining a job and performing it well over a long period despite alleged abuse actually solidifies the plaintiff's legal profile.
Wait, really? How does enduring it make the case stronger?
Well, in several ways. First, as we touched on, it proves undeniable competence. If you have 20 years of exceeds expectations reviews, the defense is legally boxed out of suddenly claiming you were bad at your job to justify a later firing.
Okay, that makes sense.
Second, the law recognizes the economic realities of survival. Employees frequently endure toxic environments because they need the paycheck, they rely on the health insurance.
Especially if they have family depending on them.
Exactly. Or they fear being blacklisted in their specific industry. Wilson's complaint explicitly states she didn't complain publicly about broader systemic issues because she was afraid of the retaliation she claims she had seen others face.
So you don't have to quit to prove it was terrible.
Right. The law does not require you to be a martyr and quit your job to prove you were discriminated against. In fact, quitting can sometimes hurt your case because the defense will argue you voluntarily resigned, which complicates claims for lost wages.
Wow. That makes a lot of sense when you reframe it from a purely economic survival standpoint. So she put her head down. She alleges she worked grueling 12-hour days, arriving at 7:30 in the morning, rarely taking a lunch break, leaving at 7:30 at night, and sometimes staying until midnight to prep for board meetings.
She was grinding.
Absolutely. She describes experiencing what she terms modern racism, or undercover racism, during this period. The way she frames it, her elite work performance temporarily superseded her race, allowing her to stay employed in advance. But the underlying culture was always deeply, quietly biased.
It feels like she spent 20 years building a structurally sound, beautiful house on top of a massive fault line.
Yeah, that's exactly it. She just learned how to balance the furniture and keep the plates from rattling while the ground constantly shifted beneath her feet.
But according to her complaint, her silence and her relentless work ethic eventually resulted in a major promotion.
But that promotion did not take her off the fault line. It just moved her to a higher, more exclusive, and ultimately more volatile seismic zone.
Which brings us to the next major era in the documents, spanning roughly from 2006 to 2016.
Right, Wilson is promoted to the executive suite. She alleges that upon her arrival, she was the only African-American executive administrative assistant on that level. And almost immediately, the undercover racism she described earlier seemingly begins to lose its cover.
The microaggressions become less micro.
Exactly. She claims she was quickly dubbed the African-American Barbie by people in the executive wing.
That specific phrase immediately flags a potent intersection of race and gender bias.
How so?
Well, calling a professional woman Barbie inherently minimizes her competence and reduces her to an aesthetic object. Adding the racial qualifier isolates her further. It frames her as a novelty in a predominantly white, high-power space rather than a peer.
It's incredibly demeaning.
It is a subtle but highly effective method of othering an employee.
And the allegations regarding upper management in this executive wing get much more specific, moving from nicknames to overt ideological statements. Wilson's boss at this time was Richard Sabo, a managing director.
And this is where the language in the complaint gets very direct.
Very. The complaint alleges Wilson routinely heard Sabo and another managing director, Richard Sampson, refer to African Americans collectively as those people. In one highly specific instance outlined in the document, she claims Sabo openly stated, "Those people think they can go to Yale and Harvard and it will change who they are, and it won't."
This allegation is a massive structural shift in the lawsuit.
Because it's so overt.
Yes. It transitions the complaint away from microaggressions or implicit bias and moves it squarely into the territory of overt, explicit racial animus from senior leadership. If a managing director is allegedly stating that African Americans are fundamentally immutably lesser, regardless of their educational pedigree from elite Ivy League institutions.
Or their professional achievement.
Right. That establishes a documented belief system. It provides the legal intent needed to prove that subsequent actions were driven by race.
And the complaint details an incident that puts this exact belief system into practice. Sometime in 2013, Wilson invited an African-American colleague, Daphne Williams, up to the executive wing for a brief visit and introduced her to Sabo.
And what allegedly happened next is very telling.
According to the documents, after Williams left, Sabo pulled Wilson aside and told her, "You work up here now, and you need to leave those people downstairs."
Staggering.
Wilson claims she pushed back, telling her boss, "I am one of them." And Sabo allegedly replied, "No, you are not like them, and that is why you are up here. If you want to grow within JPMorgan, you need to leave them where they are and pay attention to your new environment."
The psychological dynamics of this alleged interaction are devastating. Sabo is utilizing the exceptionalism narrative.
What does that mean in the legal context?
He is allegedly telling Wilson that she's only allowed in this elite room because she is the singular exception to the rule of her demographic.
Yeah.
It's a deeply alienating management tactic.
It's conditional acceptance.
Exactly. It communicates to the employee, we accept you conditionally, but we reject everyone else who looks like you, and your continued success requires you to adopt our prejudiced view of your own peers. It forces a wedge between the employee's professional ambition and their own identity.
It sounds like being handed a VIP wristband to an exclusive club, but the bouncers still stop you, pat you down, and interrogate you every single time you walk to the bathroom, while happily waving everyone else through.
That's a great analogy.
You're physically inside the club, but you're being constantly reminded that you are absolutely not a member. And Wilson claims that this feeling of conditional, monitored existence was enforced by actual physical security protocols on the executive floor.
Right. The complaint outlines stark disparities in how security was handled, transforming a feeling of exclusion into a tangible physical barrier.
She details a situation where she provided coverage for a non-black assistant named Gemma Anzac in the executive wing. Wilson claims she was heavily and unusually monitored.
How so?
Anzac allegedly had to send written pre-authorization like an email detailing Wilson's specific ID, her exact arrival time, and her exact departure time to the head of security and to all the non-black assistants on the floor.
That seems excessive for an internal employee.
It does. And if Wilson had to stay late to finish a project, Anzac's boss had to physically leave his office, walk out, and verbally authorize the time extension to security. Wilson claims that if she stayed a minute over her allotted time, she would be physically locked out of the floor's systems.
Wow.
And the complaint states unequivocally that non-black assistants providing the exact same coverage did not face these draconian, highly surveyed requirements.
Connecting them to the legal architecture, it creates a physical manifestation of the hostile environment.
It's not just talk anymore.
Right. It is no longer just verbal slights or nicknames. The actual physical infrastructure of the workplace, the security guards, the electronic locks, the email protocols, is allegedly being deployed to treat her as a persistent, localized security threat based purely on her race.
Which builds the case that the discrimination was institutionalized, not just interpersonal. And she claims this institutionalized bias directly affected her compensation and her upward mobility. During a performance review with Sabo, where she once again received glowing, stellar feedback for her work, she requested a formal title change to Senior Executive Administrative Assistant, which was a title commensurate with her actual duties.
And what happened?
Sabo allegedly refused the title change. She claims he explicitly told her that the senior title was reserved exclusively for non-African Americans.
He said that out loud.
According to the complaint, yes. He allegedly forced her into a corner, telling her she had to choose between fighting a losing battle for the title or accepting a salary bump without it. She took the money, but she states her formal title never matched her actual compensation, her responsibilities, or her peers.
If a plaintiff can prove that interaction occurred, it is the holy grail of an employment discrimination lawsuit. In legal terms, this is called direct evidence.
Because usually it's much harder to prove, right?
Oh, incredibly hard. Most discrimination cases rely on circumstantial evidence. The plaintiff has to prove that the only logical reason they didn't get the promotion was race, which requires navigating complex legal tests.
Right.
But here, the allegation is that a manager stated the racist policy out loud, explicitly citing race as the sole barrier to a promotion. It bypasses the need for inference entirely.
The complaint also suggests that this attitude wasn't just isolated to Richard Sabo. Wilson attempts to establish that this was a known systemic issue at the highest levels of the bank.
She points to the board of directors for this, right?
Yes, she points to a fireside chat held in March 2017 by James Bell, who was the newly appointed chair of JPMorgan's board of directors audit committee. Bell was allegedly brought in specifically to investigate why the audit department had 0 African Americans in senior positions.
And what did he say during this company-wide chat?
Wilson claims that Bell candidly admitted that JPMorgan's non-African American managers, vice presidents, and managing directors, on the whole, view African Americans as thieves, drug dealers, or a threat of physical violence.
Pleading that admission in a federal complaint serves a very specific strategic purpose.
What does it establish?
It attempts to establish corporate knowledge. It argues that the highest levels of the corporate board, the people overseeing the entire institution, were not only fully aware of deep-seated systemic racial bias among their middle and upper management, but they were openly acknowledging it in public forums without terminating the managers holding those views.
Setting the stage for liability.
Exactly. It sets the stage for the bank's ultimate liability for what Wilson claims happens next.
Because what happens next is the escalation. We are moving into the 2016 to 2017 timeframe. Wilson is assigned to support a new manager, Paul Jensen, who is the head of audit. And this is where the narrative introduces Janet Jarnigan, shifting the environment from upper management gatekeeping to daily, overt, suffocating hostility.
Janet Jarnigan was an executive director and a team leader in the audit department. Crucially for the environment, she sat in extremely close physical proximity to Wilson.
The complaint notes she sat less than 6 feet away.
That's right on top of her.
Yeah. And the allegations against Jarnigan are just a barrage of extreme behavior. Wilson claims Jarnigan would sit at her desk wearing headphones and routinely sing along to rap music. But she wasn't just humming. Wilson alleges Jarnigan was loudly shouting the N-word in the middle of the office.
Loud enough for everyone to hear.
Everyone in the vicinity could hear it. And Wilson was the only African-American employee in the room.
When an employee introduces a slur of that magnitude into the workplace, even under the guise of singing along to media, it shatters any semblance of a professional environment. But the legal focus often shifts to how the conflict is managed once it is raised.
And when Wilson objected to the singing, the dynamic allegedly shifted into aggressive psychological manipulation. When Wilson told Jarnigan that the songs were offensive and made her deeply uncomfortable, Jarnigan would allegedly turn it back on her.
How so?
Jarnigan demanded to know why black people use the word but get so angry when non-black people use it. Jarnigan would minimize Wilson's distress, claiming that because she was from Atlanta, she understood the culture and therefore using the word was not a big deal.
That is a textbook description of gaslighting in a professional setting. The perpetrator attempts to convince the victim that the offensive act is actually normal and that the victim's perfectly rational distress is the real anomaly.
It's wild.
But looking at this through the lens of a federal judge, this specific interaction raises the crucial legal boundary between bad office etiquette and a legally actionable, hostile work environment.
I want to dig into that boundary because it is notoriously blurry. At what point does an obnoxious, offensive coworker cross the threshold into violating federal or state law? Like if a coworker sings a highly offensive rap lyric once, is that enough to successfully sue a multi-trillion-dollar bank?
It is the central friction in harassment law. The courts have explicitly stated that civil rights laws are not designed to be a general civility code for the American workplace.
So you're allowed to be a jerk.
Exactly. The law differentiates between a mean boss, boorish behavior, or isolated incidents, and a legally recognized hostile work environment. To win, a plaintiff must prove that the conduct was either so severe or so pervasive that it fundamentally altered the conditions of their employment and created an abusive working environment.
Severe or pervasive.
Right. A single instance of singing a lyric, while a fireable offense under many HR policies, might be dismissed by a judge as an isolated lapse in judgment. The law requires a court to look at the totality of the circumstances, the frequency, the severity, whether it was physically threatening or merely an offensive utterance, and whether it unreasonably interfered with work performance.
And Wilson is meticulously pleading that this was not an isolated incident. She is alleging a highly pervasive, inescapable pattern.
Give us an example of the pattern.
Well, following the 2016 presidential election, Wilson claims Jarnigan walked into the office and loudly declared, "We are back in charge." Given the context of their previous interactions, Wilson understood "we" to explicitly mean non-African Americans.
That's incredibly loaded.
And the very next day, Jarnigan allegedly walked up to Wilson, handed Wilson her coat, and instructed her to hang it up in the closet. The complaint notes Jarnigan absolutely never handed her coat to non-black assistants.
This specific incident is critical for the legal narrative because it moves the hostility from ambient environmental noise like the singing at the desk to direct racially coded subjugation.
Subjugation, wow.
Yes, demanding a professional peer perform a menial, servant-like task and applying that demand solely based on race is a massive escalation in severity. It attempts to establish a master-servant dynamic in a modern corporate office.
The drumbeat of allegations continues. Jarnigan allegedly mocked Wilson's food choices, telling her she needed to count calories if she wanted to be beautiful. She publicly and aggressively interrogated Wilson about her finances, demanding to know how an administrative assistant could afford high-end designer clothes like Chanel and St. John.
Just relentless.
Perhaps most chillingly, Jarnigan allegedly refused to even use Wilson's name. She would stand right in front of Wilson's desk, look directly at Wilson's boss, Paul Jensen, and say loudly, "Can you tell her to get our lunch? Because if you don't tell her, she is not going to get our lunch."
The refusal to use a person's name while standing in front of them is a classic, deeply ingrained dehumanization tactic. It strips the employee of their individual identity and reduces them from a respected colleague to an object, or just a piece of office equipment in the presence of management.
And Jarnigan's commentary allegedly extended to others as well. When a coworker mentioned having to change a vacation schedule, Jarnigan allegedly quipped, "What's the matter? She can't get her green card." During a separate office discussion about a male coworker who was worried he might get hung by his wife for working too many late hours, Jarnigan allegedly injected a snide comment directly referencing the racial history of lynching, stating, "That doesn't happen to us."
When a plaintiff outlines this volume of incidents, the legal spotlight inevitably turns away from the offending employee and glares directly at management.
Why management?
Because corporate liability in these cases frequently hinges not just on the fact that a rogue employee acted abhorrently, but on how the institution's management responded the moment they were put on notice.
And Wilson claims she did exactly what she was supposed to do. She complained to her direct boss, Paul Jensen, about Jarnigan shouting the N-word and treating her like a servant. And Jensen's response is staggering.
What did he do?
According to the complaint, he completely gaslit her. He told her she was being dramatic. He minimized the racial slurs. He told her not to worry about the lunch demands, saying he would just fetch the lunch himself to keep the peace.
This is an allegation of catastrophic institutional failure. When a manager characterizes a direct complaint about racial slurs and subjugation as the employee being dramatic, that manager is effectively ratifying the hostile environment.
He's validating the abuse.
Exactly. They are sending a clear message to the victim that their emotional reaction to the abuse is the actual disruption to the workflow rather than the abuse itself. It isolates the employee entirely and emboldens the abuser.
So Wilson is completely boxed in. Her manager thinks she's just being dramatic. Her coworker is allegedly making her daily life a living, breathing nightmare. So Wilson pulls the ultimate cord. She does exactly what the highest level of corporate policy told her to do. This takes us to the pivotal period of 2017 to 2018.
The narrative now transitions to an exploration of the deep paradox inherent in the modern corporate open-door policy.
Jamie Dimon, the highly visible CEO of JPMorgan Chase, famously held global town halls where he looked into the camera and told employees to email his executive office directly with any unresolved issues.
He projected an image of ultimate accessibility and accountability.
He said, "Come to me." So Wilson, feeling abandoned by her direct managers, took the CEO at his word. Over the course of several months, she bypassed middle management and sent 7 highly detailed emails directly to Dimon's executive office, outlining the racism, the hostile environment, the exceptionalism, and the retaliation she felt she was experiencing.
This is where the narrative highlights the violent collision between high-level corporate public relations messaging the benevolent CEO town halls and the cold, grinding machinery of human resources and corporate risk management.
Because instead of a rescue squad, Wilson alleges her emails triggered a nightmare. After she started complaining to HR and emailing Dimon, she claims Paul Jensen unlawfully docked a week of her pay in retaliation for her speaking up.
That's a very tangible adverse action.
Very. The psychological stress of the environment and the perceived retaliation became unbearable. In April 2017, while at the office, she suffered a massive panic attack. She experienced severe chest pains, breathing issues, and the situation escalated to the point where she was admitted to a hospital psychiatric unit and placed on suicide watch.
She is pleading that the unbroken tension of the workplace environment literally broke her physical and mental health.
And how did the corporate machinery respond to an employee having a medical crisis after reporting racial abuse to the CEO? Wilson claims that instead of investigating her abusers, the bank immediately turned its investigatory powers on her.
They turned it back on the plaintiff?
Yes. In-house counsel demanded a complete, unredacted set of her medical and psychiatric treatment records. Furthermore, they forced her to undergo a fitness for duty psychiatric exam conducted by a doctor chosen by the bank. Wilson claims the bank fabricated a story specifically that she had threatened to physically harm herself and another employee in order to legally justify demanding this invasive psychiatric exam.
Demanding a fitness for duty exam in this context is a highly aggressive, deeply strategic corporate defense mechanism.
Why do they do that?
Well, by forcing the exam, the corporation is subtly shifting the narrative framework of the entire conflict. They're moving the spotlight away from the premise of, we have a toxic, racially abusive manager, and moving it toward, we have a mentally unstable, potentially dangerous employee.
It flips the script entirely.
It medicalizes the conflict, turning a civil rights complaint into a psychiatric evaluation.
It is the ultimate betrayal of the open-door policy. It's as if she pulled the corporate fire alarm because her desk was on fire. And instead of sending a fire truck with water, the company sent a team of inspectors to interrogate her and ask if she was legally sane enough to know what a fire looks like.
That analogy perfectly encapsulates the legal argument she is making about institutional retaliation.
And the incredible irony of this specific event is that the bank's own designated psychiatrist, Dr. Conti, evaluated her and found her entirely fit to return to duty. According to Wilson's complaint, Dr. Conti even went off script and told her he thought Janet Jarnigan was a horrible person for putting her through this ordeal.
But even after being medically cleared by their own doctor, the bank did not simply let her return to her desk.
No, returning her to her desk would put her right back in the explosive environment. Instead, they placed her in a sort of paid administrative purgatory.
Right. They offered her a separation agreement, essentially offering her money to sign away her right to sue and leave the company.
And after 20 years of building her career, she refused to take the buyout. So HR told her she had a limited window to find a new job internally within the bank. But Wilson alleges this process was rigged from the start. She claims she was sent on sham interviews for positions that were drastically beneath her pay grade, often reporting to people she already had a negative history with.
Setting her up to fail.
Exactly. When she finally managed to secure interviews for jobs she actually wanted and was qualified for, she was summarily rejected. And the official HR feedback for why a 20-year veteran was rejected. They allegedly told her she lacked enthusiasm because she didn't ask enough questions during the interview.
In the context of employment discrimination litigation, telling an applicant they lacked enthusiasm is a highly scrutinized, deeply subjective metric.
I would imagine defense attorneys hate that.
Oh, defense attorneys hate subjective metrics because plaintiffs' attorneys love them. A subjective metric can very easily serve as a convenient, unprovable pretext for a predetermined retaliatory decision not to hire or retain someone. You can't empirically measure enthusiasm the way you can measure typing speed or sales numbers.
Finally, in May 2018, the hammer fell. She received a formal letter stating her employment at JPMorgan Chase would be terminated. But the story takes one final brutal twist.
What happened?
She claims the bank intentionally did not officially process her termination in their computer systems until June because of this discrepancy in dates. When Wilson applied for unemployment benefits to survive, the New York State Department of Labor charged her with fraud, believing she was claiming benefits while still technically employed.
That is just rubbing salt in the wound.
She had to fight state fraud charges while suddenly stripped of her income and her health insurance. That is the harrowing 200-paragraph narrative laid out by Wanda Wilson.
It is a devastating, incredibly dense narrative of a life and a career being systematically dismantled. But, as we established at the beginning of this deep dive into the documents, in a lawsuit there are two distinct sides.
Right.
A federal complaint represents the plaintiff's absolute best version of the facts, completely unchallenged. Now we must shift our lens and examine how a multi-trillion-dollar financial institution, backed by endless legal resources, responds to a narrative of this magnitude.
We turn now to the defendant's answer. This document was filed by Morgan, Lewis & Bockius, LLP, which is one of the largest and most powerful corporate law firms in the world. If Wilson's complaint is a fiery, emotional, sweeping novel, the bank's answer is a blank concrete wall.
It's very different to read, isn't it?
It is systematically, deliberately, and almost frustratingly sterile.
And we need to explain why it is sterile, because it is a very specific, highly calculated legal strategy. An answer in federal civil procedure is not designed to tell the defendant's counterstory.
So they aren't arguing back here.
No. It is not an opportunity for the company to explain their side of the argument or justify their culture. Its primary singular purpose is to admit the indisputable facts that cannot possibly be denied and to categorically deny absolutely everything else. By doing this, the defense forces the plaintiff to carry the heavy burden of proving their allegations during the discovery phase.
Reading the bank's answer is a surreal experience. It feels almost insulting in its brevity and its endless repetition. Is this just standard legal strategy, or is there an element of psychological warfare here just brushing her off?
It is absolutely standard civil procedure, driven by the strict rules of evidence. Under the federal rules of civil procedure, if a defendant accidentally or intentionally admits an allegation in an answer, that specific fact is considered legally proven for the remainder of the litigation.
Oh, so we can't take it back.
Exactly. The plaintiff no longer has to provide evidence for it. Therefore, defense attorneys are trained to deny anything that contains even a microscopic hint of subjectivity, emotion, or any fact they intend to challenge later. They are building a defensive perimeter, preserving their right to fight every single point at a later date.
Let's look at the mechanics of how Morgan Lewis constructs this wall. The bank readily admits the purely mundane administrative facts. They admit she worked there from 1997 to 2018. They admit her title was Executive Administrative Assistant. They admit the historical fact that her sister died and she took leave in 2003.
Right, things they can't deny.
They admit the digital reality that she sent those 7 emails to Jamie Dimon's office. They admit the medical fact that she took leave in 2017. But the moment the document touches the emotional or behavioral core of the complaint, they deploy a blanket response. Defendant denies the allegations.
Precisely. Every allegation of racism, every devastating quote attributed to Sabo or Jarnigan, every claim of a hostile work environment, every assertion of gaslighting is met with a flat, emotionless denial.
Let's look at a specific example to see how they spin facts. Regarding the security protocols in the executive wing, where Wilson claims she was heavily monitored and required authorization that non-Black assistants didn't need, The bank's answer is fascinating.
How do they handle it?
They admit that authorization was required for obtaining access to certain floors.
Yeah.
But they frame it purely as a standard corporate security concern applicable to anyone who didn't regularly work on that specific floor. They entirely sidestep and implicitly deny the core allegation that the security policy was applied in a racially discriminatory, disparate manner.
It is a brilliant piece of legal drafting. They admit the existence of the policy, which is provable by looking at a manual, but they deny the discriminatory application of the policy, which is what actually creates liability.
That's sneaky but smart.
Very. Similarly, regarding her termination, they admit they provided feedback that she didn't ask questions in her internal interviews, which they state was perceived by the recruiters as a lack of interest. They stand firmly behind the integrity of their HR process.
But the real tactical meat of the answer isn't in the denials. It's at the very end of the document, in a section they call the separate defenses, or affirmative defenses.
This is where the defense goes on the offensive.
What does an affirmative defense do?
It essentially says to the judge, even if you assume for a moment that some of the facts alleged by the plaintiff are true, we have a separate legal justification that entirely protects us from liability.
Let's break down a few of the most important ones. Defense number 3 reads, each and every action taken by defendant with regard to plaintiff was based on legitimate, non-discriminatory reasons.
This is the absolute bedrock defense in all employment law. The bank is asserting that whatever adverse actions they took, whether it was not promoting her to the senior title, demanding a psychiatric fitness for duty exam, or ultimately terminating her employment, were driven entirely by standard business practices, objective performance metrics, or standard HR risk protocols.
Not race.
Right. They are legally declaring that race played absolutely zero role in their decision-making matrix.
Then there is defense number 8, which focuses on money. Plaintiff's claimed damages are barred to the extent that she has mitigated or failed to mitigate her alleged damages. What does mitigation mean for someone who just got fired?
In employment law, you cannot weaponize your own unemployment. If you are wrongfully terminated, you cannot simply sit at home on the couch for 5 years, file a lawsuit, and demand 5 years of lost back pay.
You have to try to get a job.
The law imposes a duty on the plaintiff to mitigate their damages by actively and aggressively looking for comparable work in their field. The bank is laying the groundwork to argue that even if a jury finds them liable for discrimination, Wilson shouldn't receive a massive financial payout if they can prove she didn't look hard enough for a new job.
Though it is worth noting that Wilson's own complaint mentions she eventually secured a demanding job in housing management,
which preemptively deflates this defense by showing she did, in fact, find work.
And perhaps the most crucial and complex defense is defense number 13. Plaintiff's claims are barred because defendant took reasonable steps to prevent the conduct. Plaintiff unreasonably failed to use the preventive and corrective measures, and reasonable use of defendant's procedures would have prevented at least some of the harm.
If you have ever signed an 80-page employee handbook on your first day of work and wondered why the company makes you acknowledge you read it, this affirmative defense is exactly why.
Really?
Yes. This is known as the Farragher-Ellerth defense, named after 2 landmark 1998 Supreme Court cases. The bank is utilizing this precedent to argue, look, we're a massive corporation, we have an established HR department, we have heavily documented anti-discrimination policies, we have a highly publicized open-door policy.
They're saying they have the structure in place.
Exactly. If this manager was acting like a rogue agent, the employee had a duty to use our internal mechanisms properly and in a timely manner. If she failed to navigate our corporate remedies correctly, or if we did respond reasonably once she finally told us, the corporation itself is not liable for the rogue actions of one manager.
They are legally attempting to shift the burden of fixing the hostile environment back onto the shoulders of the victim.
Precisely.
So we have the unstoppable force of Wilson's highly detailed 200-paragraph emotional narrative crashing headlong into the immovable object of JPMorgan's blanket denials and strategic affirmative defenses. It is a complete legal standoff. Neither side is giving an inch.
It is time to bring in the referee to see who survives the collision.
Let's look at the ruling by Judge Jesse M. Furman.
This is the moment where abstract legal theory is forcefully applied to the messy human facts. Following the answer, JPMorgan filed a motion to dismiss the second amended complaint under Rule 12b-6 of the Federal Rules of Civil Procedure.
I want to make sure everyone listening understands the sheer stakes of that specific piece of legal jargon. What does a 12b-6 motion actually mean for the lifespan of a lawsuit?
A Rule 12b-6 motion is a defendant's attempt to kill a lawsuit in its crib. It essentially says to the judge, Your Honor, we don't even need to argue about the evidence yet. Even if you assume every single word the plaintiff typed in her complaint is 100% true, she still has not stated a valid legal claim that entitles her to a trial.
It's trying to cut it off early.
It is a desperate attempt to end the litigation before the terrifying and incredibly expensive phase known as discovery begins.
Discovery is the phase where the plaintiff's lawyers get to send subpoenas, demand internal emails, and force high-level executives to sit in conference rooms and answer questions under oath in depositions, right?
Exactly. And corporate defendants will spend millions of dollars on lawyers to win a 12b-6 motion precisely to avoid discovery. E-discovery in a modern corporation involves turning over terabytes of internal communications.
Emails, Slack messages, everything.
Everything. It disrupts business, it costs a fortune in legal fees to review the documents, and it runs the massive risk of surfacing embarrassing or legally damaging internal communications that the company wants to keep permanently buried. So Judge Furman's job is to read Wilson's complaint, assume it is entirely true for the sake of the argument, and decide if the law provides a remedy for the horrific scenario she describes.
And the judge's opinion and order comes down on November 8th, 2021. The very first thing Judge Furman addresses is a procedural, almost technical argument made by the bank.
What did the bank argue?
JPMorgan argued that Wilson blatantly changed her story from her very first draft of the complaint to her second amended complaint. The bank essentially said, hey, in her earlier versions, she only talked about undercover racism and microaggressions, but now she's throwing in all these explosive, wholly new allegations of explicit, overt race-based conduct, like the use of the N-word and the Savo quotes.
They wanted to throw out the new stuff.
The bank wanted the judge to throw out all the new damaging allegations because they felt she was just inventing them to save her case.
It is a common defense tactic to attack the evolution of a plaintiff's story. But Judge Furman opts for what he explicitly calls the more benevolent option.
You mean?
He reviews the documents and notes that Wilson's very first complaint did mention racism repeatedly, even reproducing early emails where she complained of modern-day racism to HR. He rules that adding specific, explicit instances of overt racism in later drafts isn't a blatant contradiction of her earlier claims. It is simply clarifying them by adding the necessary granular detail.
So he lets it stay.
He rejects the bank's argument and allows the new, highly detailed complaint to stand in its entirety.
Which is a massive early victory for Wilson. So, with the full, unredacted complaint in play, Judge Furman looks at the three main pillars of her lawsuit: hostile work environment, race discrimination, and retaliation. Let's examine how he handles them one by one. First up is the hostile work environment claim.
This is where the geography of the lawsuit matters immensely. Because she is suing in New York, the judge must analyze this claim under two drastically different legal standards: the New York City human rights law, known as the NYCHRL, and the New York State human rights law, the NYSHRL.
The judge notes in his ruling that the city law, the NYCHRL, is incredibly broad and plaintiff-friendly. To survive a motion to dismiss under the city law, Wilson only had to show that she was treated less well than other employees because of her race.
Just treated less well.
Yes, it does not require the harassment to be severe or pervasive. Under the standard, even a single racially loaded comment could theoretically be actionable.
The Judge Furman is careful to note, reflecting established precedent, that even the liberal city law is not a general civility code. An employer is allowed to be obnoxious, demanding, or rude, provided that behavior isn't tied to the employee's protected class.
But the judge rules that Wilson easily clears this lower city bar. He points to the mosaic of allegations. The African-American Barbie comment, Sabo explicitly saying "those people" and telling her to leave those people downstairs, Jarnigan's repeated use of the N-word, the disparate security protocols in the executive wing, and the James Bell fireside chat admitting managerial bias.
That's an overwhelming list.
Judge Furman concludes that these allegations of both overt and implicitly race-based harassment easily satisfy the burden to show she was treated less well due to her race. So, the city claim survives.
But the state law, the NYSHRL, at the time these specific events occurred, possessed a much stricter, more traditional federal standard. It required the plaintiff to show that the workplace was permeated with discriminatory intimidation that was severe or pervasive enough to alter the fundamental conditions of her employment.
That's a much higher hurdle to clear.
A much, much higher hurdle.
Yet, even against this higher standard, Judge Furman rules that Wilson succeeds. He points to the persistent, documented derogatory comments from Sabo and the repeated, aggressive use of the N-word by Jarnigan despite Wilson's clear protests. He concludes that these actions, taken together, were severe and pervasive enough that a reasonable person would objectively find the conduct hostile.
He looked at the big picture.
He also notes that Wilson subjectively perceived it as abusive, as evidenced by her severe panic attack and hospitalization. So the state hostile work environment claim also survives.
Having both of those claims survive a motion to dismiss is a profound victory for the plaintiff at this stage. It legally validates the core of her narrative that the culture she endured was unlawfully toxic. Next, the judge turns his attention to the discrete race discrimination claim.
For the listener, you might be thinking, isn't race discrimination exactly the same thing as a hostile work environment? How are they legally distinct?
It is a vital distinction in the law. A hostile work environment claim is about the overall atmosphere, the ambient temperature of the office, the jokes, the slurs, the culture.
The day-to-day feeling.
Right. A discrete race discrimination claim is usually focused on a specific, singular adverse employment action, like being fired, being demoted, or being denied a specific promotion, and proving that specific action occurred because of race.
And in this case, the bank fiercely argued that Wilson completely failed to identify a valid adverse employment action. But Judge Furman zeroes in on one highly specific allegation from her time in the executive wing.
The title change.
Yes, Richard Sabo allegedly refusing to give Wilson the Senior Executive Administrative Assistant title, explicitly telling her that the title was exclusively for non-African Americans and forcing her to choose between the title or a salary bump.
The judge categorizes this specific interaction as direct evidence of discrimination. To understand why this matters, we have to look at how most discrimination cases are fought. Usually, plaintiffs do not have a manager admitting racism out loud. They only have circumstantial evidence.
People usually don't just say it.
Right. In those cases, the court forces them to use a complex, three-step framework called the McDonnell-Douglas test, named after a 1973 Supreme Court case. Step 1. The employee proves they are qualified and suffered an adverse action. Step 2. The burden shifts to the employer to provide a valid, non-racist reason, like she was late. Step 3. The burden shifts back to the employee to prove the employer's reason is a lie, a pretext.
That sounds exhausting.
It is a difficult uphill battle. But Judge Furman says that because Sabo allegedly stated the racist policy out loud as the exact reason for denying the title, Wilson gets to bypass the entire McDonnell-Douglas test. Direct evidence is a shortcut through the legal maze.
The bank tried a technical maneuver to kill this claim. They argued that it was time-barred by the statute of limitations because Sabo allegedly left the company in 2014, which was outside the 3-year window for her lawsuit.
A classic timing defense.
But the judge rules that because the complaint itself doesn't explicitly state the exact date Sabo left, he cannot dismiss it at this early fact-gathering stage. He does, however, issue a stern warning to Wilson's lawyers that they better have a good faith basis to keep pursuing this claim if discovery proves Sabo really did leave in 2014. But for the purposes of the ruling, the race discrimination claim survives.
So Wilson has successfully defeated the bank's attempt to dismiss the core harassment and discrimination claims. But then the judge evaluates the third and final claim, retaliation.
And this is where the momentum of the ruling takes a sharp turn. Wilson claims she complained to HR, she emailed CEO Jamie Dimon about the racism, and in retaliation for speaking up, she was gaslit, her pay was docked, she was forced to take a humiliating psychiatric exam, sent on sham interviews, and ultimately fired and accused of unemployment fraud.
It looks like a clear chain of events.
To a layperson, this looks like a clear, unbroken chain of cause and effect. But Judge Furman dismisses the retaliation claim entirely.
This specific dismissal highlights the massive gap between common sense and the strict definitions of federal law.
I am going to push back hard on this ruling because it feels deeply counterintuitive. She complained to the CEO, and then a cascade of terrible, life-altering things happened to her, ending in her termination. How can a federal judge look at that timeline and say, nope, there is no retaliation here?
It all comes down to the unforgiving legal definition of causation. To prove retaliation in federal court, a plaintiff must show a very tight, legally undeniable link between the protected activity, which in this case is sending the emails reporting the discrimination, and the adverse action, which is being fired. You have to plead facts that prove that but for your complaint, you would not have been fired.
But the timing of it all seems so obvious.
Timing in the law is incredibly tricky. Judge Furman references his previous ruling on her first complaint. where he noted she failed to allege a plausible causal connection. In her second amended complaint, he notes she essentially just listed the exact same retaliatory acts without adding new connective facts to tie them directly to her protected activities.
So she just restated what happened.
The law requires much more than simply saying, I complained in April and I was fired in May. You need evidence or strongly pleaded facts suggesting that the specific HR recruiters who gave her bad interview feedback or the specific managers who terminated her did so because of the complaint. If months pass between the complaint and the firing, or if there is an intervening event like a documented medical leave, a corporate reorganization, or documented objective feedback about poor interview performance, the legal chain of causation becomes hopelessly frayed.
Let me see if I have this right. Because she didn't plead enough specific, granular facts connecting Jamie Dimon's office reading her emails directly to the lower-level recruiters, giving her bad interview feedback months later, the claim fails the legal test of causation, even if it feels inextricably connected to anyone reading the narrative.
That is exactly right. It highlights how extraordinarily difficult retaliation is to prove in federal court without a smoking gun. You almost need an internal email from a manager saying, fire her because she complained about me. Without that direct link, large corporations can almost always point to other, seemingly legitimate, documented business reasons to explain the timeline of events.
So what does this all mean when we step back and look at the entire landscape? We have watched a single case travel from a tragic personal event in 2003, wind its way through the highest, most exclusive executive offices in Manhattan, descend into a hospital psychiatric ward, and finally land onto the desk of a federal judge in late 2021.
What this deep dive into the documents reveals is the immense grinding friction between a massive corporation's public-facing diversity policies and PR messaging and the alleged on-the-ground realities of middle management and corporate security protocols.
It's a huge disconnect.
It demonstrates how an individual plaintiff must navigate an absolute minefield of complex legal standards, affirmative defenses, and procedural rules just to win the right to ask for discovery.
And the fact that she survived the motion to dismiss on the hostile work environment and discrimination claims meant that JPMorgan was going to be forced into that terrifying, expensive phase of discovery. They were going to have to produce those internal emails. They were going to have to make executives like Paul Jensen or Richard Sabot sit for depositions under oath.
And the looming threat of discovery is very often the ultimate tipping point in corporate litigation.
And indeed, it appears that threat functioned exactly as expected here. As mandated by the parameters of our analysis today, we must conclude the timeline by stating exactly this. The parties in the case, Wanda Wilson and JPMorgan Chase Bank, entered into a settlement agreement for an undisclosed amount on February 14, 2022, as reported in the civil docket for the Southern District of New York.
Because the case was settled out of court, it vanishes into a confidential agreement. We will never know what e-discovery might have uncovered in the bank's servers or what a jury of regular citizens would have decided after hearing testimony from both sides.
Which leaves us with a profound, lingering question. I want to leave you, the listener, with this final provocative thought to mull over as you navigate your own professional life. If an employee does everything exactly right according to the corporate playbook, if she works 12-hour days, earns stellar performance reviews for 20 uninterrupted years, follows the CEO's direct, publicized instructions to report abuse to his office, and relies on human resources for a lifeline, and the system still allegedly fails her to the point of a psychiatric hospitalization, is the true issue a few bad Apple managers? Or is it the fundamental architecture of the corporate institution itself?
It forces us to ask. Are corporate HR policies designed to protect the well-being of the employee, or are they exquisitely designed solely to manage and minimize the legal liability of the corporation?
If you've ever signed an employee handbook, that is a question worth asking. It takes us back to our opening thought. We want the workplace to be like an X-ray, clear policies, clear infractions, clear justice. Broken or not broken.
But the reality is much messier.
As this exploration of Wanda Wilson's lawsuit shows, the reality of corporate employment law is nothing but muddy waters, where the foundation is always shifting, and the truth is buried under layers of corporate risk management and complex legal strategy. Thanks for joining us for another episode of the Employee Survival Guide podcast.
Hey, it's Mark, and thank you for listening to this episode of the Employee Survival Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So Leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.